Hello everybody and welcome to today's webinar. We've got a great presentation lined up for you today, but before we get started, there are just a few general admin points to cover. First and foremost, please use the online question tool to post any questions that you have and we will share them with our speakers. Second, if you experience any technical difficulties today, please let us know using that same questions tool and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded and we'll be sharing a copy of that recording with you via email in the coming days. So, without further ado, I would like to hand over to our speakers to get us started.
A very good afternoon to everyone and the guest speakers. Welcome to the GAR session on delay and disruption disputes in oil and gas EPC projects. The oil and gas industry is one of the largest sectors, generating an estimated income of $5 trillion in global revenue. The oil and gas projects are very complex, they are high value and have long life cycle and involve a lot of stakeholders, including various engineering disciplines and construction contractors working simultaneously on the project. The integration and interfacing of engineering, construction, and procurement phases pose a big challenge in large EPC projects. These mega projects are often prone to various disputes between the stakeholders due to technical challenges, contractual ambiguities, coordination issues, cost and schedule overruns, and design changes, leading to litigation and arbitration. This session has been organized to address how delay and disruption disputes in oil and gas projects is different from typical construction projects and requires very specific knowledge and expertise. I will now introductions before starting the session. I'm Shweta Srivastava, working with Masin, and I will be moderating this session for in and out discussion with the speakers on the topic. Let us go through the introduction of the speakers on the panel today. We have Mr. Rohit Singhal, oil and gas expert from Masin. Rohit is a construction and engineering dispute expert with 25 years of experience in international consulting and management, involving construction contract disputes and expert testimony. He has appeared as an expert in more than 70 international construction arbitration. His specific area of expertise is oil and gas projects, having worked on Asia's biggest petrochemical project and one of the longest cross-country pipeline projects. We welcome you, sir. Next on the panel, we have Mr. Giovanni Pagnaco, Senior Legal Manager from MIRE. Mr. Pagnaco is a Senior In-house Counsel currently working at Merit Technimont with a broad experience in international dispute resolution, construction law, contract and claim management. He has managed several high-key international arbitration cases, mainly related to engineering, procurement, and construction contracts for oil and gas, fertilizer, power projects in Middle East, Asia, Russia, Europe, and Latin America. Welcome you. Next on the panel, we have Mr. David Thomas, KC from Keating's Chambers. David is a hugely experienced advocate. He has been recognized by Chambers UK, Chambers Global, the Legal 500, and Whoiso Legal, where David has been recommended as a leader in his field. He advises regularly on NEC contract disputes and has conducted numerous adjudications and mediations in relation to engineering and construction contracts. A large part of David's practice arises from GCC countries, Africa, and Asia. Next, we have Mr. Julian Bailey, Solicitor and Partners from Jones Day. He specializes in the practice of construction and engineering law, including in relation to oil and gas projects. He is the author of Construction Law, 3rd edition 2020, and was chairman of the Society of Construction Law UK in 2015 and 2016. Mr. Bailey is a visiting fellow at the Dixon Poon School of Law, King's College London, and is an adjunct professor of law at Hamad bin Khalifa University, Doha. I welcome you. I welcome all the panelists again and thank you very much for joining us. So now we can start with the Q&A session and let's have an interactive and this interesting session ahead. Next slide, please. So the first topic of this discussion is feed risk on the EPC contractor. Let us have a look at a typical clause of an EPC contract. The clause specifically states that a contractor will undertake design verification of employees' feed in the bidding phase and will take full responsibility for the adequacy, stability, and safety of all design. The clause further goes on to say that notwithstanding that employer has developed specification, feed, and plans for the EPC work, the contractor will be responsible for the detailed engineering and for the provision of drawings, material takeoffs, and equipment requisition. Now, in general practice, the feed design are usually developed by the engineer in the early project phases, wherein the information available is quite limited. And this document provides a very prelim information such as the partial PNIDs, the process description, and the other technical description. Now, the typical clauses like this, which are seen in the tenders, they pass on the risk of feed design to the EPC contractor from the beginning itself. Now, because of these feed documents are forming the basis of the lump sum price being quoted by the EPC contractor. And remember, these feed design are basically the prelim designs and they are not the final designs. The EPC contractor may face potential issues because of unforeseeable feed risk, maybe underdefined feed documents leading to underestimated bids, design changes, and design conflicts. So what we would like to know today here is, Mr. David, what you can share our experience with us on how such claims are dealt from a legal perspective. Second part of this question is, who is responsible for the claims arising from change in feed? And how does good faith argument support contractors' position in such cases? Over to you, David.
Okay, well, Gillian and I will both give some thoughts on this question. But the basic starting principle is it depends on two things. Firstly, the wording of the contract, and secondly, the applicable law. The applicable law is important because that's going to define the approach to deciding what the wording of the contract means. So, for example, English law takes what's often referred to as a black letter approach. The wording of the contract is all important, and the allocation of risk allocation of risk generally is a matter for the words of the contract. It's not a matter determined by law. It's for the parties to apportion the risks between them. And to give you an example of risk allocation in an English case, there was one quite famous one in our Supreme Court about 5 years ago, where the contract said that the contractor had to prepare all the designs in accordance with a certain international design standard, and secondly, ensure a lifetime of 20 years for the equipment concerned. Well, the relevant international design standard that the contractor had to comply with turned out to have a fundamental error in it. In fact, the contractor was still found responsible because the guarantee that it would have a lifetime of 20 years was found to prevail. So that was the more rigorous requirement, and no matter that complying with the international standard would mean that you couldn't, the contractor still had to comply with the guarantee that it had given. So there's a fairly tough black letter approach from English law, which is typical. If you have a different legal system, a civil law system applying, then you can get a rather different approach. The UAE Civil Code, for example, says a contract must be performed in accordance with its contents and in a manner consistent with the requirements of good faith. Well, how does that apply? A more difficult, certainly more fluid question, I think. An error is probably not bad faith, but on the other hand, if the owner knows of the error and simply allows the contractor to, as it were, be misled by that error into an underbid effectively, then, well, maybe that could be bad faith, and so everything to play for. So those are two different sort of approaches you can get to the wording of the contract. But Julian, do you want to talk a bit more about fees?
Yeah, sure. Thanks, David. And what is paramount, certainly from an English law perspective, is the contractual allocation of risk. And as we can see from this provision we're looking at on the slide, it's pretty clear as to where the risk lies if there's an error or something like that in the fee. The risk is with the EPC contractor. And it's often quite difficult for EPC contractors to try to find ways of claiming more time or more money if on checking the feed later on an error is discovered, which leads to cost overruns. But and certainly Giovanni can speak more to this than I can, but as a matter of accepted market risk in the world of EPC contracting, certainly in the offshore world, these types of provisions are typical and they're accepted, and contractors who sign contracts that can include provisions like this are unfortunately taking on quite a bit of risk. But the experienced contractors understand that and can make provisions for
that. You do get arguments in English law even about clauses like this as to what they really mean, I think the key thing for both parties is to achieve clarity in the contract. And looking at the words on the screen, you might end up with an argument about, well, what is detailed engineering? Contractors responsible for detailed engineering. It's a defined clause. It's again categorized, so properly defined. You go and look at the definition. What does that say? All sorts of arguments about are we within or without detailed engineering. So that's the kind of typical English law argument that you can get.
Yeah, thank you very much. So as David rightly pointed out, that a contractor is required to follow a specific standard and they need to submit a performance guarantee. Now, taking that requirement into mind, let us move to another follow-up situation on the feed risk. Can you move to the next slide, please? Let us look at a situation where a feed design is based on a rely upon information and which is based on a specific addition at the time of feed. Now, at the time of signing of the contract, a new edition of the code is being introduced, which requires the rely upon information to be updated. Now, a clause like this appears in the EPC contract, which states that the contractor is required to follow the latest edition or the latest requirements. And the clause further goes on to say that the contractor is required to prepare all the additional studies required for the performance of the contract and completion of the facilities. Now, in such a case, the contractor has to use the latest codes which are available. At the same time, there is a risk of a redundant feed which is there, which can lead to further conflicts in the design and the other change orders. So again, Julian and David, we would like to have your views on the issue as to which party should bear the consequences deriving from the update of rely upon information. Is the EPC contractor responsible for this risk? What would be the legal standpoint on this matter? Julian, maybe you can go first. Yeah, you can decide. Yeah.
Well, again, the approach to a question like this is very much focused on the wording of the contract from the English law perspective. We've got a situation here where certainly the EPC contractor isn't responsible for the change in the code and couldn't likely have foreseen it. Same may be true of the employer as well. Why would he foresee a change in the code? Now, the common law does not decide in those circumstances which of the party is going to have accepted the risk. It's up to the parties to decide. So the general principle that we outlined in relation to the previous question applies here. It's a particular application of it. What some contracts do is to, as it were, baseline certain matters, and that can include in relation to certain codes and standards. And if that's true, the contractor still has to complete its design in accordance with the new updated code, but will have a variation claim. So, for example, you can get contracts, and the FIDIC Silver Book would be an example of this, where a change in law, which would normally include a change in a code law, usually gets quite broadly defined. So change in law would be an owner risk event. Now, if you've got that, well, the contractor's protected. That's an example of a kind of baselining. It's really a defining of what it is the contractor has got to design in accordance with, and saying, well, it doesn't have to design in accordance with a changed law. On the other hand, if the contract doesn't have a specific risk allocation clause like that, saying the owner is responsible for a new law, then that is probably left with the contractor. Or you might have contracts where a contractor is responsible for designing in accordance with the latest requirements. So what you've got to do with the approach is to just carefully, in English law, pick apart the clause and see what the party's risk allocation is in relation to the particular matter that's occurred, and a change in code is just one of those.
Sure. Yeah. Thanks. Obviously, I agree with everything David's just said. One thing to add, coming back to the change in law point, there's sometimes an ambiguity which can work either way, to the contractor's advantage or to the employer's advantage, as to whether a code and a change to a code represents a change in law. And that comes down to the status of the code. We have British codes, we have Euro codes. The question is, are these laws? Do contractors have to follow them as a matter of law? And sometimes it's not particularly clear, particularly if you're in the offshore environment where work it might be taking place within the waters of a particular country, and the laws of, say, England or European laws don't even apply. So a change in a code may not be a change in law for these purposes. Alternatively, if the code in question forms part of the law of the country, say English law, and the contractor is required to comply with English law, then a change in the code could be seen as a change in law.
Thank you very much. That was really insightful. So the next question I have is for Mr. Giovanni. So as an EPC contractor's in-house counsel, you must be facing several issues, several practical situations wherein an unforeseen circumstance in EPC contractor contract is being encountered. So how do you handle such situations with unforeseen circumstances? I think you're on mute. Yeah, thank you.
Sorry about that. Thank you for this very interesting question. As an EPC contractor, we have first of all to consider that we are in a so-called sandwich situation. So I mean, on this large scale petrochemical, oil and gas, fertilizing big projects on lump sum turnkey basis, we have to face the owner and also the subcontractors. So I mean, this is something I will discuss also later on. But in terms of facing these practical situations, and the situations very commonly happen in managing our projects, we have to first of all understand how we work. I mean, in our department, but not only in our company, probably also most of our competitors. I mean, we have colleagues specifically dealing with contract negotiation, and of course we work in many different countries under very different jurisdictions. So we have to have, of course, a good knowledge of the basics, distinguishing between civil law and common law systems. And of course, negotiating a big contract is a first step. And negotiating well is not always very easy. The power of negotiation vis-a-vis a client is much lower than what you have vis-a-vis your subcontractors. As a matter of fact, there are certain clauses you cannot change so much from certain standards or certain ideas, which are mostly imposed by big clients. Our clients are big petrochemical companies, state companies, so among the biggest companies in the world. So negotiating with with them is not easy. However, since we have to provide lump sum turnkey projects and our services are based on a combination of engineering, procurement, and construction. If you talk about FEED in particular, if you talk about engineering, we have to be extremely realistic, careful. Risk allocation among the three parties I mentioned before, owner, contractor, and subcontractor, is very important in a reasonable way, as far as the applicable jurisdiction allows you to move around these topics. Of course, standard contracts are very helpful. FEED contract can be very helpful. But if we talk in specifically about engineering, which is the starting point, I mean, you have to think about it. We work mostly on projects which require to detail engineering, which is initially being produced by mostly in most of our cases by licensors, very important licensors. So we have to provide detailed engineering and issue for construction drawings to our owners and to constructors, which will have to put together all the pieces at the end within a certain schedule, within certain deadlines. Otherwise, big penalties have to be paid, of course. And we have to think about the whole system of parties. We have to think about the difficulty of different jurisdiction contract, referring to different clauses, different jurisdiction standards, licensors towards which we have certain obligation, and which also serve as a limitation of our liability in a certain way, because of course it gives also some certain kind of protection on the other side, whether we have to, if we develop properly or not according to certain standards, certain drawings, which sometimes are being modified by owners in a way which is not as per the initial agreements between the parties. I mean, I want to mention cases I faced recently where the owner decided to operate a petrochemical plant in a completely different way, changing the philosophy of working on certain valves, which causes a big explosion. I mean, then I cannot disclose so much about the case, which is still currently going on. But the point over there is very much important to put it clear between the parties, which are the boundary lines, which are the liability, responsibility in developing a certain FEED, a certain design according to certain licenses, in order to be sure that your liability vis-a-vis the owner will be those that are supposed to be, and nothing more, nothing else. I mean, if there is a change on operating a plant differently from what a plant is licensed to be operated, then we have a big problem. One last thing I want to say is that in company like Tecnimont, like Maire, like Tecnimont, I mean, of course, big company like this, you have people negotiating contract, you have other colleagues managing the contract, taking care about contract management and claim management. So then there we go about how to put together proper claims or defend yourself against certain claims raised by other parties like clients or subcontractors. Then, if worst come worst, then they ring to my bell, and we have to start, if not a settlement, unfortunately, a dispute. And when you go to a dispute, all these topics come back onto your desk, and either you were capable from the early stages to properly understand which is your risk, how to allocate your risk, how to deal with your contract, the contract you negotiated, you manage to negotiate and you sign, and where are the documents which can support your position during the execution of the project, during the eventual claim phase where you are negotiating some claims, or if worse can worse, during your dispute. If you do not have a proper, let's say, management of the proper documentation, then I want to put the focus on the quality of document that could create a big problem for a company like us. Documents are always being a little bit not considered as important, the importance they have. Documents have to be contemporary, have to be complete, have to be consistent, have to be all these things. Otherwise, no tribunal in the future will recognize you any quantum, even if you will succeed on liability. And this for a company like us is extremely painful. I hope I didn't go too much far from the subject, the specific subject of the discussion, but I wanted to give you a broader view of what is an in-house counsel doing, what can in-house counsel doing, what can an in-house counsel do in managing a practical situation where they start appearing on your desk.
Thank you very much. That was really helpful to us. And thanks for sharing your experience on this matter. So let's move on to the next topic of this session, which is disruption claims. Next slide, please. Now, disruption claims are one of the challenging claims to prove, given the complexity of the oil and gas projects and the availability of the records. The employer generally argues that a contractor must establish disruption at the activity level for proper evaluation of the claims. Now let us have a look at a sample case scenario where an EPC contractor submitted a disruption analysis by considering piping erection progress, the piping material availability, and the erection manpower at the overall project level itself. Now the employer reviewed this particular claim and they rejected the claim by citing the following reasons, like this is a global claim. It does not demonstrate the disruption at the unit area or the activity level. It does not consider contractors' own inefficiencies, and there is no proper contractual basis for the disruption claims. So these are the reasons which are often cited by the employers while rejecting such claims. So here, Rohit, we would like to have your views on, did you experience a similar situation or similar kind of challenges while dealing with the disruption claims? And what is the best possible way to handle the disruption claims in your experience?
Thank you, Shweta. So this is very common in the oil and gas industry EPC projects, and to have a disruption claim which is produced at a very high level, at a project level, and the employer coming back and saying that this is a global claim, so it is not going to be accepted, and at times tribunals also rejecting disruption claims. First of all, to begin with, disruption claims are very difficult claims to prove and justify. They are difficult in the sense, and they are high value claims also. They generally, they are much more bigger in value as compared to prolongation claim, because these are disruption on the manpower and equipment involved in construction. While prolongation is more of a time related, damages which are being claimed, disruption is a direct cost claim, therefore generally is higher in value. But proving them is difficult for the bare reason that, as Mr. Giovanni said, that the documentation is not sufficiently maintained by the contractor or the subcontractors. And so a lot of times I have seen where there is no manpower and equipment allocation to the various areas. In a typical EPC project, the entire area of a refinery or a petrochemical or a fertilizer is broken down into number of units. And within one typical unit, the construction starts from grading the site, leveling the site, constructing the foundations, and then further moving on to structural erection, equipment erection, piping erection, then electrical instrumentation. All those things are going on in a sequential manner and all. Now what happens is that supposedly there is some disruptive event which is caused by the employer, which could be that the drawings are not given on time, or maybe the sequence of work is changed, or maybe there is an issue between the various interface contractors and subcontractors. Now all these are disruptive events which takes place. Now these disruptive events are taking place on a unit to unit level and on a discipline to discipline level. Like for example, there is a disruption in civil part of the project, there is a disruption in the mechanical part of the project, in the piping part of the project and all. Now, if a disruption claim is prepared and submitted by the main EPC contractor or the subcontractor at the project level, ignoring all the units, ignoring all the disciplines, and just saying that there is a loss of productivity because of which I'm intending to put millions of dollars of claim owing to disruption, then such a kind of a situation is going to lead to a global claim which most of the time the employers are reluctant to accept, and even the arbitration tribunals are reluctant to accept. So what is the solution to this? The solution to this is that, first of all, you have to do a disruption analysis, wherein the own inefficiencies of the contractor and subcontractor are eradicated from the disruption claim. Then you try to establish a direct causal link between the disruption event and the loss which is taking place, which means that, let's say, if a sequence of work is changed or a drawing is not given on time by the employer or by the main contractor to the subcontractor, you try to see the impact of that change of sequence, that lack of a drawing has affected which unit, has affected which of the disciplines, rather than at the global level, at a project level, saying a lack of drawing or a change in sequence of the work has disrupted the entire project. So you have to drill down more into the details at slightly minute levels to identify the extent of disruption, and then put in a disruption claim. And therefore, and these are, as I said, big ticket claims, should not be ignored, but are difficult to justify and can be justified wherein such kind of documentation details are maintained. Over to you, Shweta. Thank you.
Just a follow-up question on the documentation part. So while dealing with disruption claims, in your experience, what are the typical documents or the typical evidence required to support such claims in the oil and gas sector?
Yes, so I think it's a very valid question. Most importantly, in my experience, what I have seen is that generally in your daily progress report or in your construction progress records, a contractor who is undertaking the construction where mainly the disruption is taking place is maintaining the manpower and equipment on a wholesome basis, which means that if a main EPC contractor like Technimont subcontracts the work full construction to another subcontractor, the subcontractor simply maintains the manpower and machinery record on a overall project level rather than on a discipline and a unit level. Once you have a manpower and equipment record which is maintained on a unit level or on a discipline level, then justifying the disruption claim becomes easier, because then you are able to show the direct link between the disruptive event, which could be the lack of a piping material, for example, which has to be free issued by the EPC contractor to the subcontractor. And this lack of piping material has caused a disruption in fabrication of piping spools, or probably erection of the piping spools, etc. The flanges, the walls, etc. are not available. So you can establish this, and then you can link that with the manpower and equipment which are associated with the piping in that particular unit. So what you need is manpower at the unit level, manpower at the discipline level, and once you have these two details, you can directly incorporate a direct link between the two. So the most important documentation is understand a disruptive event is taking place, issue notices to the employer. Number two is try to have the details of manpower and equipment at a slightly minute level rather than just on a wholesome project level.
Okay. Thank you very much. That was really helpful. So, Julian, we would like to have your legal perspective on such claims. So what I would like to understand from you is, what are the common legal grounds for claims related to loss of productivity in the oil and gas industry? And how does the burden of proof apply in loss of productivity claims? Over to you.
Thank you very much. Well, when it comes to the burden of proof is always on the party who is making the claim, which in this particular case will be the EPC contractor. And what is needed in order to support such a claim from an evidential perspective are the sorts of materials, the evidence that Rohit was speaking about, not information at a global project, but information in relation to what the particular area which was disrupted, who the workers were, what the equipment was. I'd add one thing as well, which is critical from an evidential perspective, which is that one needs to have some kind of baseline to identify, well, what was the planned productivity in this particular area, and what was the actual productivity, where the actual would be lower than the planned productivity. So one needs to have that, and that baseline needs to be capable of being supported as well by showing that it was a realistic baseline, that the EPC contractor was able to achieve or would be able to achieve the productivity levels indicated in that plan. That's a critical element as well. I don't know whether, David, you've got further thoughts on this?
I think perhaps I just can pick up the question about the legal foundation of these claims. First port of call as ever, and this is the theme that Julia and I are on, is you've got to look at the contract, see if there is a clause that will found it. Very often in oil and gas contracts and in more broadly, it's very difficult to find an actual clause that will found a disruption claim. And frequently you're driven back to saying that these claims are based on breach of contract. There will perhaps be a clause requiring cooperation between owner and contractor. You may find that there's a breach of that in failing to issue information, failing to assist in ways that avoid disruption. You may rely on a clause that's certainly implied in English law in similar jurisdictions that an owner won't hinder or prevent the contractor in carrying out its obligations under the contract. So it may be that there's a breach of those. And that is actually a very common way to found a disruption claim.
Thank you very much for the explanation and the sharing your experience on the same. So, so after disruption claim, let us now move to the next claim, which is the delay claim. Can we move to the next slide, please? Delay claims, as we discussed in the initial introduction of this session, the oil and gas EPC projects are quite complex in terms of engineering design, the process requirements, the procurement of the LLIs, which is the long lead items, and the bulk items, the interfacing issues, the construction and the commissioning. There's a lot of disciplines, engineering contractors, construction contractors, all of them are operating on the same project, and they might have dependencies on each other. The integration and the interfacing of these EPC phases, they pose a very big challenge in large EPC projects. So because of these such complexities, various problems often occur in such projects that can lead to delay and claims on the process plants and the offshore oil and gas projects. So here what we would like to understand is, how is delay analysis of oil and gas projects different from other infrastructure projects? Maybe Rohit, you can provide your views on that.
Thank you, Shweta. So I think, as you rightly mentioned, an oil and gas project is very different from a typical infrastructure project. In my experience as an oil and gas man, it's an amalgamation of several infrastructure projects into one project. A typical oil and gas project, like a fertilizer plant or a petrochemical plant or a refinery, will have civil boundaries, will have grading, will have foundation excavation, concrete works, buildings like control rooms, etc. We'll have roads, we'll have culverts, small bridges, we'll have welding, which is piping, we'll have got equipments, structural steel, we'll have electrical cabling, we'll have got SCADA systems related to instrumentation. So it's a mix of many things. And therefore a delay claim and a delay analysis of a oil and gas is far more complicated as related to a typical civil infrastructure project like bridge construction or a building construction, because it's a mix of everything, and all the activities are tied to one way or the other to each other, and interfacing is a very difficult issue. In fact, as my experience in the oil and gas, the interface between a civil subcontractor to a mechanical subcontractor to a piping subcontractor to the design to the procurement, and also with the employer commissioning teams and operation teams when you are working partly in a brownfield area, are quite challenging issues which are very often causing delay. And it needs a lot of intricate project management skills to manage and operate such a large scale EPC project. So doing a delay analysis on such projects means you need to understand how each of the discipline and the area is linked to the other discipline and the other area. And quite often I have seen that the baseline programs which are generated by the EPC contractors at the beginning are sometimes, becomes irrelevant as the project moves on because of several practical things which happens, and therefore the sequence of works quite often changes, and there are measures which are taken by the EPC contractor to somehow mitigate the those delay issues and delay claims which have come in, and as a result of which a delay analyst and a delay expert who is undertaking the analysis must understand how these various sequence of works are tied to each other. Remember, in a typical building construction or a bridge construction, you have sequence like a scaffolding followed by concreting and all, which are plain and simple. But in an oil and gas, I can do construction in several fashions, in several sequences, which might be different than what has been envisaged at the beginning, and therefore there could be variations and deviations from the plan, and those deviations might be because of delays or might be because of other reasons. So therefore a delay analyst should have an understanding of those sequence of works and should have an understanding that how a typical EPC project is executed in terms of actual execution.
Thank you. So as you rightly said that an delay analysis of oil and gas requires a specific expertise of the area as well. So here what we would like to understand from Mr. David is that how important it is for a delay expert to have experience in oil and gas projects in undertaking delay analysis. This is a follow-up of what Rohit just said. Maybe you can highlight your views on that.
Yes, in fact, Ian and I were just talking about this. He's going to lead off, and I'll come in with some practical thoughts.
Sure. So from a legal perspective, and this is an English common law perspective, the question is, does a delay expert need to be an expert in oil and gas projects? And the legal answer to that question is no. Why is that? Well, because under English law, in relation to expert evidence, what one needs to have is a field of specialized knowledge in order to give expert evidence in that field. And it's a question of how one defines a field. It could be a narrow field or a wide field. In relation to delay expert evidence, certainly at the moment under English law, the field is fairly wide. So a delay expert can give evidence in relation to an oil and gas project or a motorway project or a project about building a hospital. There isn't a legal constraint on someone being a delay expert and giving evidence in relation to those different subject matters. That's the technical legal answer, but that's not necessarily the right answer in terms of who you want to instruct. I'll hand over to David to deal with that.
Yes, I think it's really picking up on some of the things that Rohit was saying about it being important that the delay expert has an understanding just of the way an oil and gas project works. Just needs to understand the processes and sequences so that he or she doesn't sort of go into error in analysing delay. So that sort of background understanding is important. The other angle I'd give on it, though, actually, is I think it's important for a delay expert to know his or her limitations in that regard. And it's quite often the case that you need to bring in a technical expert to actually give an opinion to link in with the delay evidence. It may be that you have to have a technical expert to say, actually, the effect of this change is that you have to do B before A now rather than A before B, and that's a technical question which is beyond the competence of a delay expert to do. Or for example, if there's been a change and the EPC contractor has taken a certain period of time to give effect to that change and says, well, there's all of this extra work involved, the owner may say, well, no, there isn't. Now, it may be that you need a technical expert to say, well, look, this is completely reasonable of the EPC contractor because this is the effect of it, this is what you have to do, you have to, because of all, I don't know, safety concerns or whatever it is reasonable, or the reverse, that this is a try-on from the owner's perspective, there's nothing like this amount of work involved in it. Now, those can be technical questions rather than delay experts. So important, I think, to have a delay expert with enough knowledge to deal with the more general matters that arise, but also enough knowledge and experience and, frankly, just being firm enough and strong enough to say to the client, I need help here. because this is not really delay analysis. This is some further input. It's something that certainly as an advocate I'm looking out for in cross-examination, that if you find an expert going beyond their field of expertise, be it a delay expert, quantum expert, or technical expert, then that's really an area where you're going to make headway. We had a good case in the UK a few years ago, where there was an expert who had little experience of giving expert witness, and the High Court judge who dealt with this case listed, I think it was 12 ways in which the expert evidence was inadequate, and described it as in the end as disastrous evidence. Now that's where you can end up with if you don't have someone, as I think we're throwing it tonight, of have just described. So it's important in that sense to have someone with the right expertise, and certainly I'm going to have a lot of fun as a cross-examiner if they haven't.
Yeah, so Shweta, I fully agree to what David and Julian said. So basically, it's a very thin line. You are acting as a delay expert, which is basically a scheduling and planning expert. Now, if a complicated technical issue or a technical issue of oil and gas comes in, a delay expert, even though he might have seen an oil and gas project, should retain and remain within the boundary limits of his expertise, which is planning and scheduling. But, you know, and definitely, and a lot of times, you know, the clients do ask myself as an oil and gas man acting as a delay expert, that why you don't take up the oil and gas technical issues as well. And I am very clear in saying that no, you need to have a technical expert. It's a process related issue or something. But at times, you know, what I have seen is that as a delay expert, if you have, as David said, as a general idea of what are the methods and sequences of execution, and a change in a possible sequence of execution, which is possible, which may not need an intricate technical knowledge, that as a delay expert you should be having an idea, and you are still not getting into the technical realms of that situation. Maybe David, you would like to add something on that? You're on mute.
Sorry,
Yeah,
I think between us we've covered it. That it is a fine line, and I think it's just important that you have a delay expert who's got the experience and frankly strength of character to say, I can go so far and I will, but I can't go here. I think experienced delay experts know that they have limitations, and where we need to bring in somebody else. That's the value of the experience.
Yeah.
I think that has given us quite a lot of clarification on this matter. So thank you very much for this. Next thing which I would like to ask is Giovanni. So this is, be it any disruption claim or any kind of claim, whenever you are handling disputes, so you must be facing some situations where the project team has been transferred or they have been demobilized, and now you have just entered the arbitration, and all the pieces of the puzzles are now missing in terms of information or the inputs required for the arbitration. So how do you handle such kind of situations?
So this is another very interesting question. I mean, it's a little bit the core of our job as in-house counsel when we have to start a dispute. I mean, it probably is the most challenging, but also the most interesting portion of our work. I mean, the team is, as a team, is made of people. And what you have really to understand that you have to deal with people, either internal resources or external resources, such as counsels and experts like those participating to this event. I mean, you have to combine different culture, different languages, different skills, different approaches all together at the same time, probably melting people that are not used to work together. Because before a dispute, I'm talking about my engineers, if they never had experience before of disputes, they tend to reason always in a way like they are still in a project. I mean, when a dispute starts, you enter in a different universe. I mean, the subject matter is the same. The counterpart was your previous client or still actual and probably maybe future client, hopefully, and subcontractors about which I have to say the same comments. The difficulties is to put everything and everybody, first of all, everybody together, in order to achieve one single target, which is to succeed in your dispute, in your case, and the ingredients that you have to deal with, since as an in-house counsel managing with international dispute resolution, such as international arbitration, you work a little bit like a cook. I mean, you have to cook different, you have different pots on fire at the same time. You have to be careful to do not burn anything, to cook different ingredients at the same time, and with the parallel task. And ingredients, what are the ingredients? Are people and documents. And I'm sorry to bothering you again with the importance of documents, which of course is nothing related to counsels or experts, but like me, counsels and experts, they have to face with the document you have. So, I mean, what I have to transfer to my other colleagues is to, as I say before, deal with documents properly as you were in a dispute from the day zero. I'm sorry to say that, because one day, if you don't have the proper schedule, if you do not have the issue for construction drawing evidence, the work fronts available, the different area of the plant, easily identified by areas, sequences, and mobilization of resources for each specific area, for each specific milestone, for big plans is very, very important. When it comes to the day that you have to have a dispute, for example, against a subcontractor, and the subcontractor is not being performing properly, and you had to substitute the subcontractor, if you do not have the proper documentation, demonstrating that the contemporary documentation demonstrating that the substitution occurred in that time, at that time, for that area, in that period, for that sequence of works, exactly in that specific moment, you might win on liability and lose on quantum, which is like winning nothing, and is very, 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 very frustrating. It is something that is to be said for disruption, for delay, for any kind of claim. For delay, I've been very much fascinated by situations where experts like Reut and Reut himself, which I had the pleasure to have on board in some of my cases, were capable to deal with distinguishing what he said before, distinguishing between the different delay on different sequences on different specific areas, because when you start a dispute, you have to go in so many details that if you don't have proper documents, proper people witnessing, and being ready to testify during cross-examination at the hearing in a way which is consistent and understandable, and allows also experts, technical and delay and quantum experts, to interact properly, you can hire the best counsel in the world, the best barrister, because in England, if you do not get a barrister, it seems that you are not good enough, but you lose your case. You might win on liability, you lose on quantum. That's it. That is like losing your case, because you don't have to calculate a return on the investment, because a dispute is not an investment, is a critical situation you have to face. But you have to see that all your effort, combining, coordinating, managing, putting together people and documents, can be successful. But again, it can be successful if you provide them with proper documents, proper witnesses, proper people, and then you hire very good lawyers like our friends attending this conference, and very good experts like Reut. But without the contents, you can have also a good case by losing, like you can have a so-and-so case, but if you have a good way to represent it, you might be surprisingly successful. So, I mean, what I can say is that, as everybody say up to now, is a combination. EPC contracts are a combination of a big complexity of many different ingredients, and you have to be a good cook, and your clients, they have to get a good meal. Otherwise, nobody will be happy, including your board, and it becomes a big issue for an in-house counsel.
Thank you so much for sharing this. Let's move on to the last topic of the discussion. Next slide, please. This is about handling subcontractor claims and managing client relationship. Maybe Giovanni, this would be interesting for you. So
Yes.
It is often challenging for the main contractor to handle disputes arising from through subcontractors without creating a conflict between the main contractor and the employer. Sometimes the claims are being raised by the subcontractors, and whenever you take those claims to the employer, they are often rejected. So in your experience, how do you handle such situations, and how do you manage subcontractors' claim along with managing relationship with the employer? So,
well, the relationship with the employer, of course, is the most important thing, is the core of our business. Then the relationship with subcontractors can become a very critical situation when you have to deal with some issues related to subcontractors. I mean, vis-a-vis a client, you are liable. You are liable also for what your subcontractor do or do not do properly. So, I mean, you have to manage relationship with subcontractors very well. Again, I'm very boring, I know that, but you have to be careful about keep the records of all the documents you need to manage your project. During the management of the project, during the management of your subcontractors, you have to be careful about spoolings, about about materials, about drawings. You have to know it's your subcontractor what is the manpower they are employing at any time. You have to look ahead. You have to foresee what can happen if you see that they are demobilizing because there is some delay, probably due to the owner, but that can have a very strong impact on the completion of your work. And is the EPC contractor scope of work to employ subcontractors, civil, mechanical subcontractors to complete the job within a certain period of time. Otherwise, liquidated damages are there just around the corner, and we always talk about millions and on such a large scale project. So you have to be very careful to manage both the two sides. I mentioned before a sandwich. I'm sorry, we are approaching lunchtime over here, so I'm talking about cooks and sandwiches. I'm sorry about that. Not drinks. I'm sorry, but the sandwich position is that you are liable towards your client, but you have to deal with your subcontractor. Your subcontractor can put you in such a delay you cannot imagine if you do not manage them properly, and they know that. And they know which are your strong points and weak points. You have to know which are their strong points and weak points. So you have to always keep a balance while you are managing your project and supporting your project managers as a contract managers, like my cousins belonging to their department do. Then the claim are being raised from both the two sides. Also from client sides, and you have to keep managing all these things. Always keeping in mind that a project doesn't end with the delivery of the completion date, but can continue later on, if not all the certificates are delivered, if not all the payments are done. So I mean, you have to keep an eye towards the future, leave the present, know the past, live the present. Understand the future, how things can develop vis-a-vis client and subcontract. The most typical claims we might get from in the chain, from the end of the chain, going backwards towards us from subcontractors are usually delay, disruption, extension of time, and change, extra work changes, variations, because I mean everybody is always capable to say or willing to try to say that your drawings were not delivered in the right sequence, the material were not delivered in the right sequence, so it caused an impossibility for your subcontractor to properly manage, organize, and plan for mobilization, demobilization. Each company has its own margin and his own number to deal with, so nobody can sacrifice a balance sheet for a project, you know. But of course, you have to always to think the EPC contract as an overall thing. You know, subcontractors so can damage you if you not deal with them properly. If you are good in documents, good in managing, settling a proper agreement, or managing well a dispute against the subcontractor, you can dismantle claims on extension of time, disruption, delay, and these kind of things, which sometimes are worth many millions. So it's not a trivial thing. Of course, you have to have good document, good people, good witnesses, good lawyers, and good experts. And they have to survive in all this mess as, let's say, decent, at least, in-house counsel. Vis-a-vis the owner is the same. I mean, sometimes there are liquid LDs clauses which are very much linked one to the other. So you might have to pay for liquidated damage for delay towards the client, but then the liability is of your subcontractor. So you can try to claim against your subcontractor without being only a respondent, also a claimant. In general, I have to say, as per my experience, what is perceived like by a tribunal in case of a dispute, like as the smallest, less protected party fighting against the biggest party, is a little bit protected by the tribunal. I should not say that, but there is a trend of listening very much about a subcontractor claiming about an EPC contractor, and an EPC contractor claiming against a subcontractor, while the counterclaims from owner towards EPC contractors and EPC contractor towards subcontractors sometimes require even a bigger effort to convince a tribunal. And then, if you don't have good documents, pray your gods. Or hire the most incredible experts and counsel, or hire much better in-house counsel than me. Otherwise, it will be quite painful. I hope I say enough, but I mean, it's a very broad discussion. I could talk for hours and days, but I believe people don't have so much time to listen to me.
That was really interesting and very insightful for that matter. So now we are nearing the end of the session. However, we have got some questions from the participants. We won't be able to take all of them. However, there are two particular questions which have been raised by the participant. The first one is for Julian and David. It says, given the contract is silent on many methodologies for delay analysis, is there any specific method used in arbitration preferred by the tribunal?
Maybe I can start in relation to that. The answer to the question is no, there isn't one single method of delay analysis that tribunals say we must have. In the end, what do tribunals want? Tribunals want a clear explanation as to why a project was delayed, why particular events caused delay. So any kind of technique that gives that clear explanation is something that tribunals really value. What I can also say in this regard is that what I find is that tribunals don't generally like analyses which are driven purely by a computer and don't have any kind of relationship to what actually happened on the project. And this is particularly an issue when it comes to time impact analysis, if that's used as evidence in an arbitration, because I think what tribunals tend to find is that just like a weather forecast, the computer might predict what a delay will be, but then you already know what the delay was because the event has reached a conclusion by the time you come to the arbitration hearing. And David, maybe you can add something to that.
Well, I agree completely with what you've said, that there's no given method if the contract doesn't say so. The key really to remember is that delay, although it's a recognized expert discipline in the oil and gas field and other construction fields, actually delay, so far as the tribunal is concerned, in the end is a question of fact. And if there's an expertise there, it's really about identifying the critical path Even that, the whole of this really, as one leading arbitrator, international arbitrator has put it, it's described today, experts, who acknowledges are needed and necessary parts. It's not to denigrate them in any way, quite the reverse, but that they are sorters of facts. And that's really what it is. It's complex facts that are being dealt with. And a tribunal, an international tribunal, is really wanting to get at the factual story. It's difficult really to get to the bottom of it. And the expert evidence is really to assist them in doing that. And so it's vital that the expert delay evidence is holistic with the factual evidence on which it must be partly dependent, both documentary and to an extent witnesses and other technical evidence, as we've discussed before, to actually tell the tribunal the story of how this delay happened, when it happened, and why it happened. Who's responsible for it? Not a matter. That's for lawyers to argue about, not for experts to argue about. So no particular method, but it's about finding a way to tell the story in a clear way.
Thank you very much. The last question is for Rohit. So we have a question on variation. The oil and gas disputes could be highly technical. The oil and gas disputes with respect to variations could be highly technical in nature, and they contribute majorly to delays and disruption claims. So how is your experience in dealing with the variations while evaluating the delay claims?
So basically, you see, Shweta, a variation is an extra work, extra change of specification or something. So there is a technical justification to it and a quantum related justification that how much is the cost of variation. Now there is a possibility that this change, this extra work could have caused a delay. So we have to evaluate that whether this variation is causing a change which is coming on the critical path. If it is causing a change which is coming on the critical path, then a variation could be a possible reason for a delay, a critical delay which might have taken place. Alternatively, at times what may happen also is that parties, when they are agreeing and discussing variations, might already be agreeing on a certain number of days related to extra time which is going to be taken by them to to execute the variation. That can also be there. But again, for a variation to cause a delay, the variation related impact has to affect the critical path. That's the bottom line.
Thank you very much. So so now we are at the end of the session, and I would like to thank the panelists for sharing their views and experience on the interesting topics and sharing their insights on the same. It was very informative for the participants, and it clarified a lot of things which we are facing on daily basis while dealing with the disputes. So thank you very much for joining us and for your time. So maybe we can, depart for the lunch.
Thank you.
All of us. So thank you so much for your time.
Thank you, Shweta. Thank you, everybody.
Bye.
Thank you.
Good day.
Thank you.
Thank you, everybody. Thank you.